The number inside is larger than last month. You don't open it yet. You know better than to open it here. 14 years old. First offense, possession of drug paraphernalia. You've done this 2,000 times, but somehow this morning feels different. Maybe it's because somewhere in the back of your mind, you still remember what you used to believe about justice. You didn't start like this. You were top of your class at Penn State Law. You clerked for a federal judge who believed in rehabilitation. You gave speeches about second chances. You had a plaque on your wall from the Bar Association. Community Commitment Award, 2003. That version of you is still in there somewhere. Buried under 14 years on the bench and a mortgage on a house you couldn't quite afford on a judge's salary. Here's how it started. Not with a briefcase full of cash, not with a threat. It started with a conversation at a charity gala in Luzerne County, Pennsylvania. A developer introduced you to someone, a man who ran a private detention facility for juveniles. He mentioned they were having trouble with occupancy rates. Occupancy rates. He used those words like they were talking about a hotel. He said that judges who understood the business reality of the juvenile justice system were rare, that he valued relationships, that he was a generous man to people who understood how the world actually worked. You took the card. You told yourself you were just being polite, but you haven't thrown it out, and you've been sitting here for 6 minutes. But you didn't throw it away. And that night, for the first time in years, you slept soundly. But you were going to call him. You just hadn't admitted it yet. 3 weeks later, you called him. You told yourself you just wanted to understand the situation better. Civic interest. Maybe there were grant opportunities for the court system. Maybe you could help these facilities improve their programming. He was warm on the phone, gracious. He explained the business model without any prompting. Private juvenile detention centers received a per diem rate from the county for every bed filled. More kids committed, more revenue. Simple. He didn't tell you to do anything. He just explained the system. Then the first check arrived, $1,000. Inside a birthday card, made out to a charity organization you were loosely affiliated with. Nothing illegal on paper, nothing you could be accused of. You should note that. The drawer was not your first instinct. The first case came 2 weeks after that. Marcus, 13, caught skipping school for the 3rd time. Truancy. His public defender asked for probation and counseling services. Standard, expected. The right call by every legal metric and every rehabilitation study written in the last 40 years. You sentenced him to 90 days in a juvenile facility. His mother stood up. She said, "He's never been in trouble before. He's a good boy." And you looked at your paperwork and said the facility would provide structure and educational programming. You didn't look at her when you said it. You didn't sleep as well that night, but you told yourself it was a single case. And maybe the structure would help, and you had done nothing technically illegal, and the facility did offer programming. You told yourself a lot of things. By month 6, it wasn't one case. It was a pattern. You began sorting cases before they reached your courtroom. Not all of them. That would be obvious. But the ones that came through with the right characteristics. Minor charges. No prior record. Families without resources for a private attorney. Those were the ones. The facility's representative had a phrase for it. He called it youth intervention. He said kids from difficult environments benefited from early structured placement. He said the data supported it. He never mentioned what the actual data showed, which was that kids placed in private juvenile facilities for minor offenses were far more likely to reoffend, drop out of school, and end up in adult correctional facilities than kids who received community-based alternatives. The public defenders noticed first. One of them, a young woman barely 2 years out of law school, came to your chambers after a sentencing. She was professional, polite. She said she was concerned about a pattern she was seeing in juvenile placements. She had prepared a brief. You told her you appreciated her diligence. You told her the court took all factors into consideration. You told her the door was always open. She filed a complaint with the state judicial board 4 months later. It went nowhere. You had 14 years on the bench, community support, a spotless record. She had 7 pages and a pattern that, without the financial records you were careful to bury, looked circumstantial. The complaint was closed in 11 days. 11 days. You've waited longer for a table at a restaurant, but here's where you underestimated the situation. There's a psychology term for what happens to people who make small compromises over time. It's called moral disengagement. The researcher who named it, Albert Bandura, spent decades studying how ordinary people do extraordinary harm while believing themselves to be decent. The mechanism is always the same. First, you reframe the behavior. You're not selling sentences. You're ensuring children receive structured programming that public schools can't provide. Second, you diffuse responsibility. The facility makes the housing decision. The county sets the per diem rates. The state approves the operating license. You just apply the law. Third, you dehumanize the outcome, not intentionally, not cruelly, but through repetition. After the 200th case file, the name on the tab stops being a child and starts being a data point. You catch yourself on a Tuesday afternoon working through 7 files in 40 minutes. You realize you haven't actually read a full file in 3 months. You're efficient now. That's how you frame it. Efficient. But somewhere underneath that efficiency, something is keeping score. You know this because you started having a recurring dream. You're back in law school, you're taking the bar exam, and you can't remember the answer to any of the questions. And the proctor is the public defender, the young one, the one who came to your chambers with 7 pages. In the dream, she doesn't say anything. She just looks at you with an expression that isn't anger. It's something closer to pity. You wake up from this dream and lie there in the dark until the alarm goes off. Then you get up. You put on the robe. You go back. Because stopping is harder than continuing. That's the thing nobody tells you about corruption. Getting in is a decision. Getting out is a different kind of decision entirely. And by the time you understand the cost of the second one, you've been in too long to survive it. You have a kid of your own. 16 now. You coach his soccer team on Sundays when the schedule allows. He got caught shoplifting a hoodie from a mall 2 years ago. You called in a favor with the arresting officer. Your son went home that night. Community service. Sealed record. Devin's file came across your bench on a Thursday. You sentenced him to 6 months. His father was a mechanic, single dad. He asked if he could speak. You allowed it. He said Devin was supposed to start a job next month. He said the boy had never been in real trouble. He said he was asking for mercy. You said it without looking at him. This court believes in accountability. And nobody did. The check that month was $12,000. You had learned to structure things properly by then. Lawyers who knew how to move money, a consulting arrangement that looked legitimate on paper. You had become, without fully deciding to be, a professional. And Devin spent 6 months behind that door. The investigative journalist came from nowhere. She had been covering county politics for a regional paper. She noticed the juvenile commitment rate in your district had tripled in 6 years, while the state average had dropped. She pulled public records. She cross-referenced sentencing data. She started calling public defenders. The young public defender who had come to your chambers was her first call. You found out about the meeting 3 days later. One of your staff had contacts everywhere. You had built a small ecosystem of loyalty, people who told you things. Corruption at the institutional level doesn't feel like crime. You don't feel like a criminal. You feel like a manager. You have decisions to make, relationships to maintain, problems to solve. The bureaucratic nature of it insulates you from the reality of what you're doing, but the journalist saw it differently. She filed a Freedom of Information request for 5 years of your juvenile sentencing records. She compared your rates of detention versus probation against every other judge in the district, the state, and comparable counties nationally. The numbers didn't lie. You called your attorney. He told you to stay calm. He told you they had nothing that directly connected payment to sentencing. He told you the financial structures were clean. He was wrong about one thing. His name was Marcus, the same Marcus from the beginning, the one you sentenced to 90 days for truancy, who served his time, who came out and found high school had moved on without him, who dropped out at 16, who had 2 more arrests by 18 because the research you ignored had been right all along. He had agreed to testify. He had agreed to describe in his own words exactly what his 90 days in that facility had done to his education, his family, and his sense of what the world owed him. He remembered your face. He remembered the way you didn't look at his mother. And here is what nobody warned you about this moment. The people you wronged don't disappear when you stop thinking about them. They just wait. The last morning you sat on that bench, you knew it was the last morning. Your attorney had called the night before. Federal investigators had served the detention facility with a subpoena. The financial arrangement, the one structured so carefully through 3 layers of legal insulation, had a weak point you hadn't known about. One of the facility's bookkeepers had kept a second set of records, not out of conscience, out of self-preservation. He wanted leverage in case the arrangement ever turned on him. You had made $2.7 million over 8 years. You had sentenced children for behavior that, in wealthier zip codes, in districts without your particular arrangement, would have resulted in a warning or a call to parents. You got through 3 cases that morning: a property dispute, a small claims matter, a traffic violation. Then your bailiff handed you a folded note. You folded the note back up. You stood. You told the clerk to recess until afternoon. You walked through the door behind the bench. You didn't come back, but before we count the cost, you should understand something. The money you made is the least interesting part of this story. Marcus ended up with a felony conviction at 22. He was working construction now when he could find work. The criminal record followed him to every job application. Devin, the soccer player, didn't go back to school after his 6 months. His father's work schedule had shifted. The team moved on. Neither of them knew your name until the indictment made the papers. Stop. Let's leave the courtroom now. Because what you just experienced as a story is, in documented legal fact, something that happened to real children in a real Pennsylvania county between 2000 and 2008. Judges Mark Ciavarella and Michael Conahan, Luzerne County, Pennsylvania. Together, they accepted $2.6 million in payments from the co-owner of 2 private juvenile detention facilities. In exchange, they sentenced thousands of children to those facilities, often without legal representation, often for minor, first-time offenses. And the offenses these children committed? You need to hear what those actually were. One child was sentenced for creating a mock MySpace page mocking her school's assistant principal. One was sent away for getting into a fist fight. One child, 15 years old, who had been caught shoplifting, was sentenced to nearly 2 years after the sentence was extended multiple times. Read that again. Nearly 2 years. For shoplifting. At 15, the Pennsylvania Supreme Court ultimately vacated more than 4,000 of Ciavarella's convictions. But those records were cleared years after the damage was already done. After school years were lost, after family bonds fractured, after futures narrowed in ways that wouldn't fully become visible for another decade. Ciavarella was convicted on 12 counts, including racketeering and conspiracy. He was sentenced to 28 years in federal prison. He appealed continuously, arguing he had done nothing wrong, that his sentencing decisions had been independent, that the payments were legitimate consulting fees. The jury disagreed. But the conviction fixed almost nothing structurally. The judges were caught. But the system that allowed it, the private juvenile detention industry, the insufficient oversight of judicial conduct, the dismantling of public defenders' resources, those structural conditions did not disappear with 2 convictions. Private juvenile detention facilities currently operate in more than 30 states. Federal oversight of the relationships between those facilities and the judges who send children to them remains inconsistent. The Kids for Cash case is the one that made headlines because the financial trail was direct and the number was enormous. But the economic incentive it exposed didn't begin and end in Luzerne County. Private juvenile detention in America is a $7 billion industry, and like all industries, it requires customers. The U.S. incarcerates more people per capita than any country on earth. including countries whose legal systems the American government has openly criticized. The pipeline from childhood poverty to juvenile detention to adult incarceration is not an accident. It is the outcome of a set of financial incentives, policy decisions, and oversight failures that have compounded over 40 years. The child who gets a second chance, the counseling referral, the community service, the sealed record, is almost always the child whose family had access to a private attorney or who lived in a jurisdiction with properly funded public defense. The child who goes away is almost always someone else. And in county after county, that pattern holds so consistently that researchers can predict outcomes based on zip code with unsettling accuracy. You don't have to believe a corrupt judge is sitting on your local bench today to be troubled by this. You just have to ask what the incentive structures in place right now actually are. Who profits when a child gets sent away, who loses, and who is watching the people who decide? The judge in this story got 28 years. The children he sentenced served their time and walked back into a world that had moved on without them. If this made you angry, it should. Stay angry. Channel it somewhere useful. Look up the Juvenile Law Center. Read the Pennsylvania Interbranch Commission report. Ask what oversight exists in your county for juvenile sentencing, because accountability doesn't begin with the conviction. It begins with the attention.